new video series from the road. It's great to be back on the road, even if it's just a little bit, here in my home state of Texas, and coming to you from a top secret broadcasting location on the Texas Gulf Coast, also known as Mustang Island. The subject of this video series is Texas civil litigation, but before I start, as I have done for the past several months, I want to give a special acknowledgement to the challenges that are facing our great nation, the civil unrest from the tragic death of Mr. George Floyd, and how we're all going to live together, living up to the rhetoric of our own revolution, that out of many we are one, as well as the seemingly unending financial upheaval from the coronavirus pandemic. We are hoping that and praying that our friends and neighbors not only heal from the death of Mr. Floyd and come together again to find a better way, but also that they can get back to work and provide for their families. So I've been doing a video series on Texas civil litigation, kind of a deep dive. I ended the last video series talking about mediation, and you know, the fact of the matter is where the parties go to a third lawyer, kind of sitting as judge and making judgment recommendations, not rulings, but recommendations as to how things may go in a courtroom with a judge, with a jury, where the risks are and whether a compromise can be struck. When cases don't settle at mediation, the next steps are to prepare the case for trial. And that usually encompasses a great deal of work, where the case has to be broken down into small evidentiary exhibits. So the results of that discovery that have gone back and forth, they have to be put into exhibits. The exhibits have to be exchanged. Pretrial motions have to be filed, motions objecting to certain exhibits, stipulations where the parties agree to certain exhibits. Other factors have to be put into essentially documents and notebooks and presented to the court for rulings, including responsibility of parties. So if there's a three-party situation and you've got, for example, just a simple construction case, not that any construction case is simple, but there's the owner, and then there's the general contractor and the subcontractor. And all three of those parties are going to be listed on the jury charge, and the jury is going to reduce or allocate responsibility between those three parties on that's one of the questions that they answer. So designation of any responsible third parties, that's another motion that can be filed. And these all kind of culminate in a ever-growing amount of work that is presented to the court at a final pretrial hearing, where these things are all argued. And pretrial hearings can last anywhere from 30 minutes to half a day, or even longer, depending on the complexity of the case.